The Supreme Court allows Texas now to use a congressional map favoring Republicans in next year's elections. This comes despite a lower court ruling that says the map likely discriminates based on race. The Supreme Court's order puts the ruling on hold at least until after the High Court issues a final decision in the case. The map gives Republicans 5 additional House seats. North Carolina and Missouri followed with new maps, adding an additional Republican seat each. In response, California voters approved the ballot measure to give Democrats an additional 5 seats there. The maps in California and Missouri are facing legal challenges. Judges did allow the new North Carolina map to be used in the 2026 elections.
So joining us now, we have our chief legal analyst, Khalif Rhodes. And Khalif, what did you make of this ruling?
A lot of times the Supreme Court is consistent in its ruling and its thought process. This one didn't step away from that. This rendition of the Supreme Court is extremely intent in ripping apart a number of things in the Voting Rights Act of 1965. Clarence Thomas has made it his point. He said it a number of times in a number of cases that we need to figure out how to erode and pull back some of those things. They've done it a number of times over the years with Section 2, which was used to make sure that states had to get permission before they did a number of these changes. And now this is an attack on it. And I want to make sure I let folks recognize that this isn't my thought process. What I love about the legal process is that there's a court of record. So you can look at the record. You can see the things that they're said. You can see what the courts have said in the past. You can see what this court has said. And so let's look at this case specifically. The court right here with the Supreme Court, 5-paragraph opinion. Texas is likely to succeed on the merits. They said the lower court improperly inserted itself into an active primary campaign, causing confusing and upsetting the delicate federal balance of state elections. The lower court, not a 5-paragraph statement, but a 106-page opinion. That's how large that opinion was of the lower court. And this is what Justice Kagan said. Thursday's order announced that Texas may run next year's election with a map that the district court found to have violated all of our often repeated structures about race in district courts and districting in our country. This is something that I say is probably not confused, but disturbed. And so I want to make sure that I'm clear when I read these things. Folks are so far removed from history that we forget why we have these things in place. We had the Voting Rights Act of 1965 because of Jim Crow. Southern states were saying, you know what, 15th Amendment, I don't have to listen to you. I'm going to do what I want. I'll implement Jim Crow acts. I'll have literacy tax. I'll have poll tax. I'll have grandfather clause. I'll have white-only primaries. I'll have purging of black voter rights from the rolls. These are things that are on the record. So because we needed these things, this is why we implemented the Voting Rights Act of 1965. It wasn't somebody said, you know what, let's just throw that up there. It was in response to the suppression of votes. So now these types of things right here are, yes, President Trump was saying we need to go ahead and try to find ways to keep seats. But this is voter suppression, just in a different form.
Okay, so with this decision, and like we said at the beginning, North Carolina has already been approved for next year. Does this, how will this change the legal challenges for California and Missouri?
California is different because it was a voter referendum, constitutional pass. So I think that is different. What happened in Texas is that it was passed by the General Assembly. It was passed by its congressional delegates. And because that occurred in California, in Texas, that's why it was challenged. They went and just ripped up the maps. And it was challenged by ACLU. It was challenged by Latino coalitions, folks that were saying, you are taking these majority groups and sporting them out in a place where they have no ability to select anyone. And that is what the challenge was. And historically, that challenge would have been successful even at the Supreme Court level. That's why I go back to this 106-page opinion. Let me say this as well. Courts can get it wrong. Our Supreme Court has gotten it wrong. And we forget that. Let's read a couple of them. 1857, Dred Scott decision. This is probably the most racist statement ever to come out of the Supreme Court. The Negro has no right which the white man is bound to respect. That's not me. I didn't write that. This is from our Supreme Court. So when folks say, hey, they're the best, they're the smartest, they can be wrong. Plessy versus Ferguson. Laws permitting and even requiring separation in places where they are liable to be brought into conduct do not necessarily imply the inferiority of either race. This is the court saying that, you know what? We probably should allow separation because it's okay. This was in 1896. And then the last thing is when a man has emerged from slavery, There must be some stage in the progress of his elevation when he takes the rank of a mere citizen. 1883. This is from our court. This is from our highest court. After folks have challenged to even get there, this is the court smacking them back down and saying, not so fast. So what I can say is that this is a couple of steps back in the terms of progression as a country where we were at least attempting to ensure that folks had equal rights. This is not happening now.
But this court opinion, this is not a final decision, right?
It's final. In November, they gave an interim decision. Then this hearing today allowed them to say they'll go forward with this election. So in the primary and the general in the state of Texas, those maps will be final.
All right. Khalif, thank you. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.